All right, thank you everyone. We've got our economic update coming up. I wanted to introduce really quickly. Our moderator is Lou Young. He's a partner at Witham in New York City. And then we also have on stage Paul Maitre. Paul is the Senior Vice President of Regulatory Affairs for the National Auto Dealers Association. He directs a team of attorneys who represent dealer interests before the federal executive branch agencies that oversees dealer operations. Paul is the author and editor of numerous NADA publications, and he serves as the governing committee of the Conference of Consumer Finance Law. Paul is a common speaker at these conferences, very intelligent individual. I think you're going to learn a lot. And we also have the privilege of having Rich Stocks on stage. Rich is the managing partner at Bassox Mercer Law Firm, which is focused on the representation of motor vehicle dealers over the last 30 years. He represents dealers across the country on franchise issues, including disputes with the manufacturers, franchise legislation, advertising issues, succession planning, regulatory and employment compliance issues, and in dealership transaction matters, including ownership transfers, corporate governance documents. In addition to all these things that he's an expert on, he oversees the motor vehicle dealer franchise area of his practice, and he leads BSM's work with state and metro dealer associations. Rich is also one of the nicest guys you'll ever meet, and he always has a smile on his face. So, thank you.
Thank you very much. Welcome, everybody. We're going to get into this quickly here, cover the legal issues and some of the regulatory issues that are out there. I've known these two gentlemen for close to 20 years, maybe a little bit longer, and they're very insightful. We'll get into these hot topics. I'm going to take challenge with Jay, his comment in the last session, the most important question of the day. I think the most important question today is what's going on with direct sales? And for the answers, I'm going to reach over to Rich. Why don't we get started?
All right, thanks, Lou. So direct sales, that issue is not going away. A little background on that. You've got state franchise laws that address direct sales in every state, and states fall in one of three categories. One is a strict prohibition of any manufacturer selling direct. Two is a wide open market for at least the direct sellers like Tesla and Rivian. And then there's a middle ground in states that grandfathered in a certain number of Tesla locations. So there's a handful of states that did that. And so that's the backdrop. And then more recently, what we're seeing is Rivian and Lucid going to some of these states, especially where Tesla has their 6 or 7 dealerships they're allowed to have, and saying, well, what about us? Let us open up stores as well. So that has been a battle that the dealer associations in several states have been fighting the last 2 or 3 legislative sessions. So far, so good, but those other direct sellers are not going to go away. And then on top of that, you've got dealer associations that are going back into their state legislatures to try to strengthen the direct sales prohibition to at least make sure that it's clear that the legacy OEMs cannot sell direct, that they can't set up a new brand, a new EV brand, and say, well, it's a new brand, so we can sell direct like Tesla does and like Rivian does, and cut out our dealers. That legislation has been, so far in the states we've assisted in, been met with a fair amount of resistance from legislatures because they don't really understand, well, why can't the customer choose to buy the vehicle the way they want to? So the state dealer associations are trying to do a better job of talking about why the franchise system is the best system for the customer, for the residents of that state. And then at the same time, you've got the legacy OEMs. When that legislation is presented, those legacy OEMs are saying, well, you know what? If the direct sellers can sell direct, we want that option too. And when we look at them and say, does that mean that you want to sell direct and you want to cut your dealers out? No, 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 that's not what we mean. We just want the option. So that's kind of the lay of the land legislatively. Legally, there have been several challenges to direct sales laws. So the first one I wanted to mention was in Illinois. Rivian was issued dealer licenses there, and the dealer association there challenged the issuance of those licenses. And recently, the court ruled against the dealers, saying that the judge did not read the law to prevent Rivian from selling direct. So that's now on appeal, but that's a big concern for dealers, certainly in that state, and they may need to consider going back to the legislature and clarifying that further. In Texas, Lucid has challenged the restriction on direct sales here, and that was filed recently, relatively recently, and there hasn't been a ton of action in that case yet, but Lucid is not standing still and allowing that prohibition to stand. Instead of going to the legislature, they just filed a lawsuit, and they're arguing some constitutional challenges that we've seen before when other franchise statutes have been challenged by the manufacturers. They're arguing equal protection violation, Commerce Clause violation, things that I won't get into too much detail here, but I feel pretty confident based on our history with defending franchise laws that those constitutional challenges are not going to prevail. And then the third case I can think of is Tesla challenging the Louisiana prohibition on selling direct. And that is getting really interesting because Tesla named every single commissioner on the vehicle board in Louisiana as a defendant in that case. Many of them are dealers. And one of their big arguments is this is collusion on the part of the dealers to keep the competition, i.e. Tesla, Rivian, Lucid, out of the state. So that case has also been filed relatively recently. There's motions to dismiss that are pending there, and no ruling yet on that. So that's kind of the state of things legislatively, legally, on direct sales. It's not going to go away.
Well, let's get specific with EVs. We see EVs being carved out or talking about EVs being carved out. With Ford specifically, there's been a lot of press, there's been some resistance. What's the current state of affairs with the Ford case and where we stand with that topic?
So the Ford EV program really stirred dealers up like I haven't seen in a long time. I think everybody in the room has probably at least heard about it anecdotally. If you're not a Ford dealer, what Ford's EV program proposed was first that you had three choices in terms of how you wanted to go forward as a Ford dealer. You could choose to have full access to EVs. Secondly, you could choose to be a limited EV dealer, which is selling no more than 25 per year. Or third, you can just continue to sell ICE vehicles, even though I think we all know that there's not going to be many of those produced within a few years. So Ford really gave dealers an impossible choice. And the problem with the allocation categories, as I call them, the full access to EVs or limited access to EVs, is what came with those requirements was a one-size-fits-all list of charging requirements that were way above what would be needed in many stores based on their planning volume and their units in operation. But Ford said everybody's got to have a publicly facing charger, everybody's got to have this many chargers in the store, this many chargers in the service bays, without any consideration to the size of the market and the dealer's business potential. So in the franchise laws in every state, there is a requirement that if you have that brand vehicle or that franchise, you are entitled to every single vehicle manufactured under that brand, no matter what the powertrain is. The only thing the dealer's required to do is what's reasonably necessary to sell and service that vehicle. So traditionally that's been understood to be training, special tools, equipment. But Ford went way beyond that with all these additional requirements, saying that if you don't do all these things and commit to do all these things, you're not going to get any EVs. So dealers were up in arms. State dealer associations wrote very strong letters to Ford saying, you know, this violates the franchise laws in our state. Dealers push back, and right now where things stand is we have our law firm, along with our local counsel in New York, has sued Ford on behalf of four Ford dealers in New York State. And the arguments there are a violation of the franchise law and allocation that I just described, and an adverse modification claim in some states like New York and in Florida, in my home state. If the manufacturer alters in an adverse way anything regarding your franchise, you've got a right to protest that. So we've added that claim, and we've added a few other claims under the statute in New York. The other actions that we're aware of is the Arkansas dealers have filed a protest in front of their vehicle commission challenging the EV program on various points. And who am I missing? There's one more.
It's, you mentioned...
No, it's not Connecticut. Here we go. I have my notes right here. Lawyers can't go far without their legal pads. South Dakota, they also challenged the Ford EV program. And in Illinois, a large group of dealers, 27 Ford dealers in Illinois challenged the EV program. There's one other thing about that EV program I want to mention that's, I think, much more of a concern for dealers than the unreasonable facility requirements. And that's the e-commerce platform that Ford set up as part of, if you want to sell EVs, you're going to be doing it on our our e-commerce platform. And that e-commerce platform means dealers have to post all their new vehicles and the pricing for those new vehicles on the Ford e-commerce platform. There's a minimum and maximum price that's set by Ford Motor Company, tied to those vehicles, and whatever price the dealer posts on the website, that's what they have to sell the vehicle for under the terms of the EV program. Then to make matters worse, the customer, of course, like with a lot of manufacturers now, can order direct. So they're going to go to that same e-commerce platform, order their vehicle direct, designate which dealer they want to complete the transaction with, and if they have a trade-in, the e-commerce platform values the trade-in based on a questionnaire to the customer, and the dealer who has been designated the dealer to complete the transaction is going to be bound by that trade-in value. Sight unseen. So the e-commerce platform, I think, long-term is the bigger concern for dealers. It's moving towards that agency model that was mentioned earlier today, giving the manufacturers more control over the sales process.
A couple more topics, Rich, and then we'll flip over. There's talk of subscription, add-ons, things that the manufacturer's talking about, allowing the customers to buy, subscribe later on. How should the dealers be addressing that? What should they be thinking about?
Yeah, so the subscriptions, the concern that I think dealers should have about the over-the-air subscriptions is that is all part of the product that dealers have the right to sell under their franchise agreement. You know, everybody uses the example of the heated seats or the heated steering wheel, and now, if you listen to the way the manufacturers want to present this, now those features are not going to be turned on at the time of the retail sale. They're going to be offered over the air at some point after the retail sale directly from the manufacturer, and the offer is pay us $10 a month and we'll turn your heated seats on. Well, the dealer used to be selling those heated seats at the time of the retail sale. That's a product the dealer has the right to sell. That's what the franchise agreement says. So with that backdrop, I think the best thing dealers can do, and what we're seeing happening now, is adding to the franchise protections in the law in each state some discussion of how those subscriptions are going to be handled. And what I've seen so far is two different ways of doing that. One proposal that's out there is to require that any subscription, over-the-air subscription, other than a safety update or a recall type update related to a warranty issue, but like we talked about, a feature in the car, that kind of over-the-air update has to also be available to the dealer to offer over the air. Now, I don't know technically how that all works, but there are dealer groups in certain states that are saying that's the solution we want. We just want to be able to compete on a level playing field with our manufacturer in offering those products. Then the other option is to allow the manufacturer to do that, because they may have the best capability of doing that, but telling the manufacturer that they have to share in those revenues with the dealer who sold the car for some period of time. So those two different concepts are out there now in some proposed legislation.
One last issue for you, Rich. We've had a lot of talk about planning volume, allocation. What are the things that we really need to be paying attention to for allocation, especially coming out of the pandemic when things got thrown out of whack? What should we be watching for?
That's a great question. We're getting tons of complaints from dealers, and have been for a while, on allocation. And not just, hey, the manufacturer's not producing enough cars, but I'm not getting my fair share of cars. And really what we've seen is this production environment that we're in, this constrained production environment, has made that small pool of cars that the manufacturers have always held aside and allocated on a discretionary basis. That pool of cars is making the difference between winners and losers in the dealer body. Because those cars, they're not just one more car for the dealer to sell that another dealer doesn't get. That car earns another car through the regular system of allocation going forward. So it's a double whammy, those discretionary vehicles. So we're telling dealers that they really need to closely track allocation that's coming to them and is also going to their competitors in their state. Because what we've seen when we complain on behalf of a dealer about, hey, it doesn't look like we're getting our fair share, the manufacturer just says, well, that's just a snapshot in time. You know, it could have been that the other dealer that's got all the cars on his lot, all of a sudden, he just got a shipment in. You've got one coming in a week. That's an apples to oranges comparison, so they just brush it off. So what dealers, the best practice for dealers who are concerned about how they're being treated from an allocation standpoint, we believe, is to take that same snapshot twice a month, beginning of the month, middle of the month, for 2 or 3 months in a row, and then put those numbers together. And when you complain to the manufacturer and demonstrate the unequal treatment over that period of time, it's a lot harder for the manufacturer to say, well, you're just looking at one point in time, and I'm sure things will change for you in a week or two. So the other thing, unfortunately, that dealers may need to do is file a lawsuit, because every state has laws that protect dealers in receiving their fair share of cars. And we've unfortunately, I think for everybody involved, have had to file 2 lawsuits in the last 6 months against manufacturers on allocation, one being Hyundai and the other one being General Motors. And they both center around both the discretionary pool of cars as well as the cars that are being delivered through the regular allocation system. And then there's one other lawsuit I'm aware of that we're not directly involved in, but are familiar with, and that's the Porsche lawsuit everybody read about in Automotive News, where the collection down in Coral Gables, Florida, sued Porsche because Porsche has a stated policy that you won't get any discretionary vehicles if you don't comply with all their facility requirements. Just a blanket policy. And so the collection's in a situation where they don't believe that they can justify the expense of the facility upgrade that's being requested. real estate in Coral Gables is like real estate in New York City. It just, for automotive purposes, it doesn't exist anymore. And so they're landlocked and they can't do what they're being asked to do. And Porsche said, sorry, that's our policy, you're not getting pool cars. And again, those pool cars are making the difference between winners and losers. So that's another lawsuit that's been filed in the last 6 months, and it's going to be interesting to see how they all shake out.
Great. Paul, let's start with some of the public policy issues out there. On the regulatory and legislative side, what are some of the hot topics now in Washington?
Well, of course, from the legislative side, a very big one, and certainly one of interest to this group, is going to be the status of LIFO legislation. There's also efforts to try to address the whole problem with catalytic converter theft. There is all kinds of activity with EV tax credits, as we've all heard, and that continuing saga. And then we've seen a ton of activity from the Federal Trade Commission. Very active agency, a lot's going on there.
Let's start with the LIFO legislation. Where are we with that, and what's the status?
Well, we're encouraging the prospects for the LIFO legislation. Remember how things closed out with the last Congress. Last Congress, you had a situation where there were 60 co-sponsors for the LIFO relief in the Senate. That included the majority leader. It also included, on the House side, 175 co-sponsors. This is bipartisan. 2/3 of the tax writing committees from both houses were on it. And the Senate actually passed it by unanimous consent right at the tail end of December. Of course, there were no revenue provisions put in the omnibus, so there was not an opportunity there. But as a standalone, it did get passed in the Senate. It was not taken up by the House. Of course, you hit the reset button when you go into a new Congress. Obviously, legislation has to be reintroduced, but certainly those types of support, that type of support that occurred, is going to hopefully continue the momentum to try to get this passed. So we still need to press for it. We need to continue to engage our grassroots network, but we're hopeful we can have a breakthrough there.
And that'll be a credit that you'll be able to take going forward in future years, or you'll have the option?
Yeah, that's exactly. Well, first of all, of course, this is an election. No one's forced to do anything with this, and this would pertain to recapture that occurred in 2020 and 2021. To the extent it's made up by the end of 25, that is the inventory levels, then the opportunity to have a credit as opposed to having to amend the taxes, that is really how it's designed to operate. We'd have to get into the Treasury regs that would spell all this out, but those are some of the simple elements to it, some of the more attractive features that we think would cause a lot of dealers and their CPAs to pursue the election.
Why don't we touch on some of the EV credit regulations? We're waiting for some things to come out. Where are we with the EV tax credit?
The EV tax credits, we certainly are waiting on Treasury in terms of the sale of the vehicles. In terms of the leasing of the vehicles, I think as everyone has heard, those are restrictions that really are just not present as they are on the sales side. So the EV credits can go to the finance company, or in this case, the leasing company, and they can choose how they would apply it. Now, it is something where you have to have taxable income in order to benefit from it, and certainly finance companies and others have to assess their situation there, but they can be eligible for the credit, they can apply it, and to the extent they do it in terms of some type of credit or adjusting the residual, how they go about it is really their call. What amount they go about it is their call. The nice thing for dealers is it's not something that they have to sort out and they have to manage like you would on the sales side. So of course, the next big step on the sales side will be Treasury guidance. That's expected in the next couple of months.
And everybody should know there is a template that NADA has for the report process when you have a customer who comes in to buy an EV and get the credit. So you can go to the website and they have some help for you in terms of that report. Let's go to one of your favorite subjects, the FTC. You're juggling quite a few balls in the air at the same time there, unfortunately. Why don't you give us an update on the safeguard rules and then, of course, the unfair practice regulations that are out there. Try to keep it under 2 hours.
Yeah, I was about to ask how much time we had on that one. FTC safeguards rule. So I think everyone knows kind of the core of what's going on here. Basically, the rule has been around since 2003. Financial institutions are subject to it. You have to have a comprehensive written program to protect your information because there were a slew of breaches happening at all levels of society, to universities, hospitals, businesses, et cetera. The FTC felt the need to tighten up the standards. They imposed a series of technological minimums, things like you have to make sure that information that is customer information that's transmitted when it's at rest or is in transit is protected. You have to have multi-factor authentication. You have to do penetration testing, et cetera. All those requirements were put in place for every financial institution as a result of the amended safeguards rule. In addition, there are also requirements applicable to service providers, and that's one of the bigger challenges. To the extent that you have a service provider, a dealer has a service provider, and a service provider is anyone with access to customer information that performs a service on the dealer's behalf, then they have to take a number of steps. And this one's a little more challenging. This is not just in-house or getting a vendor to line up these other things. You basically have to exercise due diligence when you select them. You have to make sure that the contract with them, the service provider agrees to protect the customer information they're entrusted with. Now that's been around since 2003. The new requirement that was put forward by the amended safeguards rule is the dealership also has to, or any financial institution, has to monitor the service provider to ensure that they are fulfilling their contractual commitment to protect the information. So that's all a big lift. And by the way, that can apply to OEMs. An OEM can be a service provider. If they have access to information, they're performing some discrete service for the dealership, they are not excluded from this requirement. So dealers have to manage that issue, and that one can be particularly tough. Fortunately, we did put in for an extension on the compliance date, the final compliance date. It was granted in part. It was going to be December 9th, 2022. It's now June 9th, 2023, so we have really urged dealers to do everything in their capability in these extra months they have to try to tighten that up. The FTC has indicated that's going to be a priority to certainly try to make sure that the safeguarding obligations are fulfilled. So that is where that stands. Now remember, that is a final rule. We're just talking about the compliance date. Shifting over to what Lou was asking about is the proposed, what we call vehicle shopping rule. And this was this massive rule that the FTC proposed in 2022. And unlike what the FTC typically does, where they are amending and tweaking existing rules, like they did with the used car rule back in 2016, or what they did with the safeguards rule more recently, this is cut out of whole cloth. This is brand new. They think there's problems with voluntary protection products, what they call add-ons. They think there's other problems in the marketplace. And instead of using their individual enforcement authority to go after alleged bad actors, which is very targeted, it does not throw a flood of obligations and burdens on everyone else. They are using this blunt instrument of a rule to just impose a series of new restrictions and duties on dealers. And they're incredibly comprehensive, and we think very problematic. And we filed a very long comment letter to the tune of 140 pages to lay out what we thought were not just public policy flaws and operational flaws in it, but what we think are many illegal aspects to the way they went about putting the rule out. So we have flagged that for the FTC. We think that they should hit the reset button and revisit this. But really, this would involve a series of new disclosures, a change to advertising requirements. It would require dealers to completely revamp their websites. It would completely expand the record-keeping obligation, all in the name of trying to make sure that there's greater transparency for customers in the sales process. And one of the many things we cite as a flaw is that the FTC never consumer tested what they've proposed. And that's a very standard feature to any type of proposal. You know, if you think about it, I'll just use one thing by analogy. Back in 2002, there was a HUD proposal. They said that when someone is shopping for a mortgage, they know that they get the amount of a mortgage broker compensation when they go to closing. They should know it earlier in the process. That amount should be disclosed. That sounds great. Until they did consumer testing. They did quantitative consumer testing, and they looked at over 500 customers, and they said, okay, in the name of transparency, this is very laudable. However, what they found was that customers were fixating on this figure, and in many cases, they were selecting more expensive mortgage products. So they said if you're going to require mortgage brokers to disclose their compensation and not others that provide mortgages, it creates a bias against mortgage brokers. And in terms of where the consumer is affected, consumers often select more expensive products. And there has been consumer testing with all kinds of mandates. If you go back to 2001, you remember, and Lou, you and I used to be involved in, I remember at NJ Carr with the whole situation with the privacy rule, where you had to give out these privacy notices. At the time, they were kind of a mess. They were all different shapes and sizes. The FTC engaged in a multi-year process with other agencies to consumer test disclosures so that a privacy notice that goes to customers is meaningful and you can compare the privacy policy of one financial institution versus another. Here they've come up with all kinds of new disclosures, 4 new written disclosures if someone wants to purchase a voluntary protection product, a series of new oral and written disclosures related to other items, and there's no indication they did any consumer testing whatsoever. So they have no idea if this is going to enhance the customer experience or confuse them and cause them to make unwise and counterproductive purchasing decisions. They just have not tested it. The whole process was rushed. They never announced it in advance. They never did anything on the front end. You know, typically something of this magnitude, you have an advance notice of proposed rulemaking. You try to inform yourself so that you can develop an informed proposed rule. They completely skipped that step here. They allowed a 60-day comment period. We asked for an extension. They granted that in the case of the proposed amended safeguards rule at the time. Here they denied it. They're very much on a fast track to get this out. They ignored the cost-benefit analysis that you are supposed to do when you put out a rule like this. They did one, but it was one that was without any substance. It was just based on assumptions. There was nothing, no type of scientific validity to it. And they've also taken a number of other steps to just short-circuit the process. So we have a situation where it was a rush proposed rule. It was not, there was no due diligence in order to make sure that it is properly thought out. We think it would wreak havoc on the marketplace, increase costs for small businesses, not benefit consumers, create a lot of unnecessary liability exposure. And again, our big message to them is we believe they should hit the reset button and take a more deliberate, thoughtful, grounded approach, data-driven approach to how to move forward with this.
What's the chances of that happening?
Is there press in the room? Well, it's, I would tell you that, you know, yes, we're hopeful that they would do that. We do have, on a more serious note, we do have conversations with their staff. We try to emphasize these type of things. In our comments, we laid out a lot of considerations. So the hope would always be that the commission would come back and they would say, okay, there's elements to this at a minimum. There's elements to this that we need to revisit. We do need to take a look at some of these disclosures. We should do consumer testing. We should try to look at what this is going to do to the length of the sale process, et cetera, et cetera. And I would not ever say that there's no possibility of that. I will tell you, though, having seen the aggressive agenda and the speed with which they're moving out, we are concerned that that would be something that they would not entertain.
Just from 10,000 feet, what do you think, have the election results had any changes for the automotive industry? Is NADA viewing it as a positive, or it'll be, you know, business as usual and not much will get done?
Right. Well, the new Congress, of course, just took effect this month, so obviously it's early, but yes, we do think it's going to have an effect for 2 reasons. First, anytime you have an agency, or I should say an administration, that is trying to push for a number of changes, and they had the ability to do it initially legislatively because they controlled both houses of Congress, and they lose that ability, their only means to try to affect those public policy initiatives is to go the regulatory route. We saw this with President Obama. Think about the first 2 years of his presidency, the Affordable Care Act, the Dodd-Frank Act. These were major pieces of legislation. He really took it on the chin in the first midterm election, lost control of both houses of Congress, could not get major initiatives passed, and so what happened? Things started to get pushed by executive order and through administrative agencies. So here, of course, the Democrats have retained control of the Senate, but they have lost the House, and the ability to push things through legislatively is going to be greatly hampered. We can expect to see even more regulatory activity than we've seen already. The other thing, Lou, is that from an oversight standpoint, the House Republicans have indicated they do intend to exercise their oversight responsibilities, and that's something that should pick up quite a bit from the last Congress.
I had a question for you. On the challenge to the safeguards rule, if the FTC ignores NADA's objections and comments, is there a legal mechanism for challenging the way the rule has been put in
Unfair
place?
practice rule, the challenge to unfair practice.
Yeah, to the vehicle shopping rule. No, very good question. So what is the legal status of that? Well, we do believe there's a method to challenge it legally. And in fact, if you see our comments, we certainly try to preserve the ability to launch a legal challenge. Of course, we wouldn't have standing until the rule is finalized, and we'd have to see what's in the final rule. To Lou's point, there could be adjustments. We'd have to assess that at the time. However, we believe that there were a number of things that were done that are contrary to law. And we actually ticked off quite a few of them in the comments, but the most glaring is a lot of people say the Dodd-Frank Act, one element of it was, if you recall, the CFPB does not have authority over dealers from a regulatory or enforcement or supervisory standpoint. They really exercise no authority over dealers to the extent they assign their paper to a finance source. But what happened was when that exclusion, Section 1029 of the Dodd-Frank Act, was passed, at the 11th hour, what was tucked into it was the authority for the Federal Trade Commission to go ahead and promulgate rules in a more streamlined fashion. However, that is what they were authorized to do, not what they were directed to do. If you look at the FTC's own procedures, their own procedures require that these type of rules be preceded by an advance notice of proposed rulemaking. What they did here was they skipped that step. They went right to a proposed rule. So we think that while that might not run afoul of what they were authorized to do in Section 1029, they still have to abide by their own rules. We believe they did not, and we believe that that's something that is a flaw that could be challenged in court. So we'll see where this goes. The ball is in the FTC's court in terms of next steps, but certainly that's something that could play out depending on how things shape up from here.
A lot to keep score of. We have a question. Rich, why don't you take it?
I'll read the question. It's thoughts on Porsche not allowing new vehicles to be displayed on third-party sites, including a dealer group's parent site. So I just read this policy that came through to Porsche dealers, I think yesterday or the day before, and I believe Cadillac has issued something similar over the last couple days. This looks a lot to me like, without any more detail, the Ford e-commerce platform I mentioned earlier. And the concern again is that dealers would have, the manufacturers would have a lot more control over the sales process if dealers have to move their display of vehicles, advertising of vehicles, pricing of vehicles, all onto a manufacturer-sponsored website. So that's a big concern. Now, there are franchise laws in place in several states that say that that a manufacturer cannot require a dealer to utilize a product or service that's mandated by the manufacturer if the dealer can demonstrate that they have another product or service of similar like-kind quality that they want to use instead. So the first thing I would point to, if that law exists in your state, is, hey, you can't make me use your website. I have my own provider I want to use, and I'll follow all the other rules, but I don't have to shift my website onto your master website and give you control over it.
I wanted to mention, besides Ford, are there any other manufacturers out there that are keeping you up at night, so to speak, to reuse the phrase?
Yeah, I mean, right now Hyundai and Genesis is really probably keeping our phone ringing as much as any other manufacturer, and there's some logic to that, because in the old days Nissan used to keep our phone ringing nonstop, and the common denominator there is Jose Munoz, who's now running Hyundai Genesis, and he's ruthless when it comes to enforcing manufacturer policies on facilities. As I mentioned earlier, they're one of the manufacturers that's playing loose and fast, we believe, with their vehicle allocation. And on the facility piece, they are really pressing for separate Genesis stores, decoupling the Genesis from the Hyundai, and ignoring the franchise laws that exist that say a dealer doesn't have to do that unless they can justify that new separate franchise, a new separate facility from a financial standpoint. Can they get a return on investment? And when dealers are pushing back saying, hey, that makes no sense. You know, I'm selling 5 Genesis a month. You can't get me any more than that, even if I could sell more than that. So I can't justify separating the brands out. Hyundai and Genesis both say, we don't care, and you're not going to qualify for very lucrative per car incentives if you don't do it. You're not going to get allocation if you don't do it. So there's a lot of angst there, for sure.
Paul, very quickly, what's going on with the tax legislation? I mean, can you handicap the probability of the legislation that ended in the last session under the, was it Inflation Reduction Act, or right after the Inflation Reduction Act? Are any of these tax increases on the horizon, or do you think that's mostly on hold?
Yeah, I don't think that's thought to be something that's imminent. You cannot rule it out, but
I want some good news today, Fred.
Yeah, exactly. I thought you were going to ask, though, about the employee retention tax credit.
Well, we can talk about that too, real quick. But
yeah,
so
no, I don't think that's on the horizon in terms of, certainly not in the short term. But we'll see how it plays out. I mean, a lot of things are still getting formulated.
We are getting a lot of questions. We're getting a lot of calls. We're playing defense with the employer retention credit. There have been some very public statements made by the IRS recently, but we're still seeing a lot of dealers requesting, looking at, thinking about some type of supply chain disruption eligibility. And can you just give us a quick overview of what the IRS has come out with in the last few weeks?
Well, with regard to the employee retention tax credit, certainly we do not give tax advice to our members, and we don't tell them whether they qualify or not. But we certainly have told them to be cautious in claiming it if they're not basing it on revenue reduction. I mean, there's 2 criteria, as we know. And this, of course, came into play once you did not have to choose between the Paycheck Protection Program and the Employee Retention Tax Credit. Once you were eligible for both, assuming you qualified for both, you could pursue it. But the big issue here is the 2 bases to qualify. You have revenue reduction. That's just math. That can be figured out easily enough. Where the issues really come up with is there a full or partial suspension of the operation of the business or the business's supplier? And that is one where the IRS has been very clear to say if someone is going to claim that, among anything else that might be out there, it must be based on a U.S. government shutdown order that is COVID related. That's a U.S. governmental entity, federal, state, or local, not the government of Singapore, not any other country in Southeast Asia. It must be from a U.S. governmental entity. It must be an order, not a statement by some public official. It has to be in the form of an order. And also, it must be COVID related, not the result of a hurricane or something else that caused a disruption to someone's business. So if someone is going to qualify, what we have urged our members to do is whoever is promoting the program is to ask them to substantiate the basis for it and then take it to your accountant and decide whether or not you qualify and then how you're going to claim it. To do anything less than that, we think, invites risk. And Lou, to your point, yes, the IRS certainly has been vocal about that. In fact, they issued a notice on that again in October saying that they are concerned about this, they're looking at that, and they do have FAQs on point addressing the elements that I just mentioned.
Great.
We got one more question.
One more question?
Yeah, the question is similar, I think, to the last one. It says, can a manufacturer withhold money if we don't use their vendors? So the answer to that question is it depends on what your state franchise laws say. I would look for the provision I mentioned earlier about vendor choice. And then also, a lot of states have provisions that address per car incentives and when a manufacturer can withhold those from a dealer and when they can't. And between those 2 provisions, there should be some relief there.
Any other questions out there? Anybody want to stand up and make a statement or ask a question? Okay, with that, I think we'll finish up. Thank you very much. Thanks, guys. We're going to take a short break.